Hi, my name is Attorney Walter Knott with Disability Resolution PA. I'm going to be calling it for a night pretty soon, but I thought I would save one topic that I've been trying to figure out how to really describe to you guys in a simple, easy manner. And now that I've put it down on paper and looked at it, I've realized that I've made it significantly more complicated than it needs to be. So I'm going to put you through that. But remember, this is an in-depth look at essentially how the SSA, when adjudicating disability claims, looks at evidence. Here we go. Okay, how does evidence work in a 2021 SSA disability benefits claim for SSI or SSDI or DSC or AUX benefits? Here we go. All right, first and foremost, where does it come from? The categories of evidence, we got to look at the categories of where evidence comes from. Could be medical, administrative, legal, academia, penal, vocational, just any category you can come up with. That's where evidence comes from. Impairments, you need to prove that you have them. And their severity. So that's kind of evidence we're looking for, right? You have an impairment, it's severe. Symptoms, which are the resulting limitations or signs of an impairment, like pain, shortness of breath, fatigue, inability to stop texting me 6 paragraphs of information when people have questions at a time. That's the kind of evidence they look for. Things that are the signs that you truly have the impairments that you claim. Evidence. They look at the claimant's daily activities. The location, duration, frequency, and intensity of the pain or other symptoms, precipitating and aggravating factors, the type of dosage, effectiveness, the side effects of any medication, treatments other than medications for the relief of pain or other symptoms, maybe it's a TENS unit, maybe it's therapy, any measures the claimant uses or has used to relieve pain or other symptoms, and other factors concerning the claimant's functional limitations due to pain or other symptoms, pushing, pulling, remembering, focusing, climbing, sitting, standing, anything with an ing on it is what they're looking for. Well, it's really a set list, but pretty much they'll examine anything. Now, a lot of people get that. Evidence is anything out there that which could prove that you have severe impairment. But how do they weigh it? Right? How do they weigh it? When do we know the evidence is enough? Right? When do we know it carries enough weight to win the day? Okay, so here comes the brilliant part of how I thought this through and thought this was amazing. I'm going to teach them this and they're going to think it's amazing and oh my God. And then I read through it and realized this is way too complicated. But let's try it. If you don't like it, you can get a different flavor next time at the store. All right, here we go. There are levels of evidence, burdens of proof, if you will. I'm going to go through them right now. We use them mostly for crim law and civil law. So the big laws. No evidence. No evidence. There is no trace of evidence. A scintilla of evidence. That's like the smallest measurable amount of evidence. It's like whatever's directly above no evidence. Reasonable suspicion. That's based on specific or particular facts or reasons, not a hunch or a guess. Probable cause. Okay? Reasonable or trustworthy information that is likely true. Preponderance of the evidence. More likely not. More likely than not. This is actually the standard in civil cases. That's what you have to prove by preponderance of the evidence. That's what you have to prove to win a claim in a civil claim. Okay. Clear and convincing. We're going up, by the way, and how hard it is to prove. If you think we're going to do this stuff, or we're going up. How hard it is to prove. Clear and convincing evidence. That is where one has a firm belief or conviction that the evidence is correct. Now we're getting into the upper echelons. Reasonable doubt. This is where it requires elimination of very reasonable doubt. This is the standard in crim law claims. Okay? So civil law, preponderance of evidence, that's the civil law standard to prove a claim. All the way up here are preponderance. Beyond a reasonable doubt. Reasonable doubt standard is what's required for essentially crim law claims, okay? Which is almost absolute certain that, you know, this is the only outcome or the only truth that there is. Now let's go to number 8. Absolute certainty. It is irrefutable evidence. Okay, that's without any form of doubt. 100% belief. You definitively know, you know, that this is the truth. All right, so now you know these burdens of proof, right? So you've got no evidence, where this is all about how much weight are we giving to evidence? How is a judge going to weigh this evidence? You've got no evidence, scintilla of evidence, reasonable suspicion, probable cause, preponderance of evidence, clear and convincing evidence, reasonable doubt, and then irrefutable evidence. All right? Now, let's go through what we could categorically put disability evidence in for those types of evidence. I know this is way too complicated. I don't know why I did it this way, but maybe I don't know. Okay. Let's go through it. No evidence. That could be basically where there's no proof at all that you are disabled. Not even lies in the record. There's just no proof at all. Scintilla of evidence. You can claim you are disabled without facts, right? I'm disabled, but it's subjective and you have no proof, right? But basically, you know, you're able to say, you know, there might be something which is in question factually, right? So you have some proof, but you're not, you know, that's more than no evidence, but there's maybe some questionable evidence in there. Hey, maybe. So that's scintilla, right? Reasonable suspicion. You explain your disabilities that are backed by old medical records. So back in the day, you were this person. We don't know how you are today, but we have reasonable suspicion you might still be that same way. Reasonable suspicion, right? Probable cause. Everybody knows that one. Everybody's been pulled over by the police at some point. I have. All right. We're talking about police reports, machine output reports. That's the reasonable or trustworthy information that is likely to be true, even though they often put the wrong date on, get your license plate wrong, etc. There, you know, hey. Preponderance of the evidence. That's where a non-specialist physician does a report on you, right? So we're talking general practitioners. They know you. They've gotten to know you. They're likely not going to screw this thing up when giving a report on where you're currently at. All right. Clear and convincing evidence, right? Now we're talking about medical imaging with specialist verification. We firmly believe it's correct because the machine said so, and then a specialist agreed with it and then showed why. That's clear and convincing evidence. Now, reasonable doubt, right? Now, remember, you could always switch these up. I'm just giving you examples of where they could potentially be, which is why now look at this. I think this is way too complicated, but reasonable doubt that you are disabled. Well, you're an amputee. The pieces are not there anymore. They're not there anymore. So even when the specialist could have read the wrong report and given a decision on it, even when the specialist could have just been not having a good day and wrote the wrong thing or gave the wrong standard or did the wrong medical thing, with this, we know de facto, okay? With this, we know de facto the parts are no longer there. There's without a reasonable doubt. Okay, so that's that. All right, now let's go to the final one. Absolute certainty, irrefutable evidence. What could be more irrefutable than an amputee? You perfectly meet a cow with all required medical information, or you are currently in a coma. Right? Because then you definitely couldn't work. If you're in a coma, you're not working. You're just not going to be working. That is like irrefutable, absolutely top of the charts, definitive evidence. That's where all the doctors say, you're blind, you're dying from cancer, or one of those gigs, and you truly are, and you can't, yada, yada, yada. That is your irrefutable evidence, without any form of doubt. All right, now look, when I made this, I thought it was brilliant, and then I reread it as I was about to do the video, and I realized there's a lot of wiggle room in there. I know, but just think of it as kind of like a general way that's kind of a way to look at what weight you could afford to certain types of evidence relevant to your claim, and what the judges are doing in their brain when they say, okay, well, this is really good evidence, this is meh evidence, this is meh, you know. All right, let's talk about the carrying of weight, even negative or inaccurate evidence versus factual positive evidence. When we look at giving weight, we look at those amounts, right? We just went through no evidence to irrefutable evidence. Now let's talk about things like a nurse to a specialist. When they look at medical evidence from a professional in the medical industry, the very bottom you've got your practitioners. And then you've got your varying degrees, your advanced registered nurse practitioner. That's also going to be probably your chiropractors, things like that, and your physicians, your physicians with some sort of, you know, plus. Then you get your specialists, board certified, your double board specialists, yada, yada, yada. So that's how they look at that. They go up the chain and afford more weight of evidence to the proper sources based on that. Now, you've also got, this was the old rule. They changed it, which was a bad choice. They need to change it back. You had seeing versus non-seeing physicians. And now what they're saying is that's still the rule. I'll go through the other thing. When you see a doctor, the evidence is supposed to be worth more than a non-seeing physician who just reviews your records. Okay? And what they basically got into there is that they started to erode in their law what basically would count as having more evidence of your doctor having more weight than their doctor having more weight. And obviously you're going to see your doctor more often. Your doctor's going to have a better long-term relationship with you. The doctor's going to understand more of what's going on because they've done more tests on you than their doctor, who's going to basically see you for 10 to 15 minutes, maybe an hour, and then give a resulting decision. Obviously you would expect the doctor that's been seeing you all that time to have a better opinion and greater weight of the evidence. Not anymore. No, they changed that rule. Yeah. Third-party agency. Okay, so I put that in there. So basically, the bottom line is that they've changed the rules of evidence to be more SSA favorable for their doctor to go ahead and have equivalent standing so long as it's seeing versus your seeing doctor. Now, remember, you have two types of evidence. You have objective evidence and subjective evidence. Subjective evidence is what you're saying. There's no tie to a system that has either educated the person or is a machine output that gives definitively objective evidence. Subjective evidence is you're coming out with it because you feel this way about it, right? Your testimony about the pain you feel is subjective. A machine that measures the pain you have is objective. Okay. Then you have friends and family testimony. You know, I always love when the judges come out and say, well, their testimony has to be reduced in weight because they are more likely to color their testimony based upon the relationship that they have with the claimant, blah, blah, blah. Even though they're not willing to use that same argument when the person who they hire as a medical provider specialist to review the patient, the claimant, only does SSA disability claims now, does not meet with regular patients, and only makes money from the SSA. Therefore, obviously they're not biased because they gave an oath and testified that they're not biased. Even though their entire paycheck comes from the SSA for doing these. Even though they've stopped practicing in total and only do SSA-based consultative examinations. Even though they haven't had an office for the past 15 years. All right, bosses, co-workers, that tends to fall into the subjective evidence, but it's very good for the vocational element 4 and element 5 of the 5-step sequential process. Insurance program reports, those can be good. There can be doctors there to give details about what the person can or cannot do. However, they also do tend to stab the person in the back by saying the person can do more than they can actually do, because let's remember who pays for those doctors who write those reports. Police reports are really great. There's usually some sort of typo on them. But the bottom line is those are good to prove time, place, what happened, basic facts. In Florida, they don't do a good job with the facts. I don't care who you are, but the write-ups are always like... they're not even bullet points half the time. They're like quasi sentences that don't have all the stuff. But I'm not complaining. It is what it is. All right, so let's talk about this. You have treating sources, you have non-treating sources, you have seeing physicians, you have non-seeing physicians. So these treating sources versus non-treating sources, these are people who are actually working with you as treating sources. You're talking with them about medication. They're talking with you about, okay, well, what's the next step? If this works, if this doesn't work, medically, where do we go from here? And then you have non-treating sources, right? These are people who are not actually there to treat you. There's no doctor-patient relationship. They're just to give basically a medical review if they want, through the SSA. This is a different breed of medical, and it could be other forms of evidence too, but it's a different breed of medical animal. Okay. Then of course we already talked about seeing versus non-seeing, the doctor that physically sees you versus the doctor that does not physically see you. And the not seeing you doctor, usually never even learn about them, but basically DDS, Disability Determination Services, will send out your claim to an internal SSA doctor who will review all the medical evidence in the file and then give an opinion based upon whether or not you are disabled. And they use that largely to define whether or not you will be found disabled. Okay, and all these people, they make reports, and these reports help people adjudicate the claim that are not medically astute, having a history of education in the medical field or other fields like a medical history or clinical findings or laboratory findings or diagnosis or treatment prescribed with responsive prognosis and any opinion statements. So these are all things that are used as part of evidence to help you basically, prove your claim or hurt your claim. So I know that this was a terrible way to approach doing how is evidence considered, and I get that. How is it weighted by the judge, and I get that. But think of it that way. No evidence until irrefutable. Think of it that way. What kind of evidence do I have? Is it good? Is it not that good? What kind of evidence do I really have here? I've got a bunch of nurses saying I'm disabled. Well, they've got a specialist that says you're not. The specialist saw you for 15 minutes. Your nurses have seen you for the past 5 years. What kind of evidence do you have, really? Just kind of start to think of it that way. I guess that's the whole point of this video, is to try and get people to wonder and think about evidence in a different way, which is, what is my evidence worth? Right? Is it worth a lot? Is it not worth much at all? Is it going to save the day? Is it just a side note? Letters from friends and family, they're just side notes. All right. Anyways, guys, remember, like, subscribe, 5 stars if you can to any of those websites out there that review me, Google, Better Business Bureau, Avvo. Also, if you want the most up-to-date information or custom video, shoot me an email, give me a call. Also, if you would like to catch up with me through the live, I go live 8 to 10 every Thursday Eastern Standard Time on YouTube. Thursday, 8 to 10 Eastern, YouTube. I'll catch you a little bit later. We'll go from there. Thanks so much. Bye-bye.